so much for joining our webinar. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today's webinar is conducted by the incredible Stephen Marso, an Iowa construction lien law expert. Today's webinar topic is Lien and Bond Claim Masterclass, everything they don't tell you but should. So without further ado, I'd like to introduce the fabulous Stephen Marso.
Thanks, Jesse. Hi, everybody. I'm Steve Marso, and I'm here in Des Moines, Iowa. And if you're listening to this right now in Iowa, you probably got hit with a snowstorm last night, so you might see some snow in the buildings behind us, but perfect weather to start talking about lien and bond claims. So before we get into the details of it, I'm going to go through some slides with some information about the webinar. If you have questions, feel free to click on the chat box on the right and send questions, and I think Jesse will let me know at the end of this if there's any questions, and I'll answer them at the end. And a caveat, don't include your names or companies in the questions. Okay, so we're going to start. We're going to talk about mechanics liens, bond claims, some contractual claims provisions, and then lien waivers. So the first subject here is our liens, and I'm going to start on Iowa's Mechanics Lien Act. So this first slide provides the deadline that a lien claimant has to file a lien. And as you'll see from the emphasized language, it's 2 years and 90 days after the last day of work of the claimant. So that's the general deadline. However, Iowa has a 90-day deadline as well that provides some additional protections to a lien claimant. And this is the provision that talks about that. And as you can see, if you're a lien claimant and you file within 90 days of your last day of work, then one of the advantages you get, and it's the bottom part of this slide, is you get what's called a relation back priority. And your priority, your lien priority, relates back to the date you started work. That can be important because everybody knows property has a finite value. And in Iowa, the lien or the mortgage, for example, whatever it might be, the first in line gets fully paid out of whatever equity is in the property. And if there's anything left, it goes to the second person in line, and so on. So you want to be first in line if you can, and this relation back is a way you can do that. So as a lien claimant, you want to try to file within 90 days of your last day of work. If you don't, you're not necessarily out of luck, but it could affect your ability to ultimately get paid. So if you file beyond 90 days, so we mentioned, the 2 years and 90-day general deadline, and then this 90-day deadline. If you miss the 90-day, but you're before the 2 year and 90-day one, you can file your lien. And if you do that, you have to serve the lien on the owner, just like you would a lawsuit. And that you have to do that to perfect your lien. If you file within 90, you technically don't. Although I still recommend you still serve the lien, even if you're within 90 days, but technically you don't. But if you're beyond 90 days, you have to serve the lien on the owner to perfect it. And another disadvantage, if you file beyond 90 days, you lose that relation back. We talked about that. So your lien is only good, or your priority date is the date you serve the lien on the owner. So you lose that relation back if you had filed within 90 days. Another thing that's a negative if you file beyond 90 days is the value of your lien is only good to the extent of the balance due from the owner to the general contractor. So if you file your lien on 100 days after your last day of work, the owner's fully paid the general by that time, your lien's worth zero. If you file within 90 days, you don't have that problem. So that's another thing to keep in mind. If there's a bond though, if you file a lien beyond 90 days and they bond off the lien, the owner loses that protection, and so then you can get your recovery for the full amount due. So keep that in mind if there is a bond that's given to bond off the lien. What's the date to file a lawsuit on a mechanics lien? It's 2 years and 90 days from your last day of work. So just keep that in mind. There is one caveat. If a lien claimant receives a written demand to file suit on their lien, then the deadline is 30 days from that demand. And if you don't file within the 30 days, you lose your lien. Absent that, it's 2 years and 90 days from your last day of work to file a lawsuit. Finally, there is in the commercial context, commercial project context, there is one written notice requirement for certain lien claimants to preserve their lien rights. It's anybody who does not have a contract directly with the general contractor. So you're a lower tier sub. So you're a sub to a sub, for example. You have to give a written notice to the general contractor, providing the information noted in the statute. Is pretty basic, but you have to do it within 30 days of the first date of work. And if you do not provide that timely written notice, you lose your lien rights. In addition, when you file your lien, you have to certify that you complied with the notice. So that's the commercial construction notice requirement. If you have a contract directly with the general, you don't have to do this. It's only lower tiered claimants. Now, residential, I'm not going to spend a whole lot of time on that other than to say there are various notice requirements of general contractors and subcontractors in residential projects that do not exist on commercial. So if you're in a residential situation, talk to your lawyer to make sure you understand what notices need to be given, because they're much more onerous, and if you don't provide the notices, you can lose your lien rights. Residential construction, just so you know what it means, is the single family and two family dwellings we typically understand, but that last part, the chapter 499B, that addresses and applies to apartments or condominiums in certain circumstances. I'm not going to get into the details of it, but if you are on one of those projects, an apartment or condo, you need to talk to your lawyer to see if you have a residential project. And they will be able to investigate and find that out. And if it is, you have to comply with the residential notices. If it's not, then you are under the commercial guys, and you might commercial project rules. And as we noticed, you only have one notice requirement if you don't have a contract with the general. So keep that in mind for residential construction. Finally, attorney fees. There's a provision in the statute that says in residential and commercial projects, the prevailing plaintiff, again, that's the lien claimant only, may be awarded attorney fees. There's also a provision here that applies only to residential, which means a person challenging the lien can recover attorney fees. So the rule is on commercial projects, only the lien claimant can recover attorney fees under the statute. On residential projects, both the lien claimant and the person defending can recover attorney fees, whoever prevails. Okay, on to bonds. So for private bond claims, I'm not going to get into the details because the general rule is this: you need to strictly comply with all the bond requirements if you are making a bond claim. So written notices, deadline to file lawsuits, various requirements. My suggestion to you is get a copy of the bond and make sure you comply with all the requirements. Strictly comply. That way you're not going to get hit with a defense that you didn't comply with some requirement in the bond. Okay, now I'm going to go to public bonds. In the state of Iowa, for state and local projects, public projects, you can't file a mechanics lien on public jobs in Iowa or public property in Iowa. Any such lien is void and of no effect. So what Iowa has developed, and a lot of states are a little Miller Act. In Iowa, it uses retainage and bond in place of the ability to file a lien. So the retainage portion comes from progress payments. As you can see here, the statute allows the owner of the project to hold up to 3% of every progress payment owed as retainage. That just got changed recently. It used to be 5%. It just got reduced last year down to 3%, but that is the retainage fund, and that's used to pay subcontractors who file timely claims. In addition to the retainage, there's also a bond requirement. So the general contractor has to furnish a performance and a payment bond. And that bond, as you can see in this provision, one of the provisions is that it is there to pay all essentially subcontractors who are owed money. And you'll notice in the middle of this slide that the bond comes into play only when the retainage is insufficient to pay claims. And so in Iowa, how it works is the claim is technically against the retainage, not the bond. And then if you prove your right to retainage and the retainage is insufficient to pay your claim, then the bond comes in to pay the difference. So a lot of people think in public projects in Iowa that, well, if I can't recover from the retainage, I'll just make a claim against the bond. That doesn't work. You got to make a claim against the retainage, and if your claim against the retainage is barred for some reason, then you cannot recover against the bond either. So how do you perfect your claim rights on public jobs in Iowa? Well, you have to file your claim with essentially the project owner. So if it's a school project, you file it with the school board, the school district, headquarters. If it's the city, you file it with the city council, the city, wherever the city hall is, for example, you would file it there. So it's with the owner. It's important to remember. It's a written claim, it has to be itemized and sworn to. It has to be notarized. Note here that lower tier subs who furnish only materials, so a supplier, for example, who is furnishing materials to a supplier is not entitled to a claim. So that's one exception under the Iowa's Little Miller Act. What's the time period to file a claim? Well, the general rule, the first section there is you have to file your claim no later than 30 days after completion and final acceptance of the project. So when the owner finally accepts the project, it starts this 30-day clock, and you have to file your claim within 30 days of that. If you don't, generally your claims are forfeited. However, there is an exception in the second section you'll see there. After that 30-day period, you potentially have the right to file a claim. There's certain conditions that have to be met. One, the owner cannot have paid the full contract price yet. If they've done that already beyond 30 days, and you're beyond 30 days, you're out of luck. And there has to be no lawsuit pending concerning the rights to that retainage. So if both of those conditions are met, plus another one that the courts have imposed here, and you'll notice that in the lower part of this, there has to be at least one timely claim filed within the 30 days. So for example, if the 30 days expires and there's been no claim filed by anybody, and then the first claim is filed beyond 30 days, that claim is going to be untimely and not permitted, even if the owner still has the retainage and there's no lawsuit yet. If there has been a claim filed within 30 days, and then the 30 days expires and a claimant comes in and files, their claim is timely as long as they had a contract directly with the general. That's another requirement for this second part here. So if you're a lower tier sub who doesn't have a contract with the general, you cannot take advantage of the second option there to file beyond 30 days, even if there's a timely claim filed within the 30. Okay, so the summary here, if you have a contract directly with the general, you have to file within 30 days. If you miss the 30 days and you're beyond 30 and there's another claim that's been filed within 30 and it's timely, you can file your claim beyond 30 days generally. I'm not going to get into certain exceptions to that. However, if you do not have a contract with the general contractor, you have to file within 30 days. Regardless, if you're beyond 30 days, you're untimely and your claim's going to be forfeited. So that's the general rule. Okay, this provision just says if a contractor abandons, a general contractor abandons the project or is terminated, then the final completion and acceptance trigger event that I mentioned to start the 30 days, it actually starts from the termination, for example. So that's something to remember. If you're a subcontractor and your general gets terminated, you need to understand that termination date starts the 30-day clock to file claims. Now there's an exception. A court can allow a claim to be filed during the pendency of a lawsuit. So we looked at the 30-day rule, the exception to that. If there's a lawsuit already filed and you haven't filed a claim, you can go into court and ask permission to file your claim. You might be denied, it kind of depends. And there's various other potential requirements, but just understand that if you miss your 30 days, you might still be in luck, but talk to your lawyer about that and see what your options are. There is a notice requirement. It's the same type of notice as in the mechanics lien context. So if you have a contract directly, if you're a subcontractor and your subcontracts directly with the general, you don't have to do a notice. But if you're a lower tier, sub to a sub, for example, you have to give the same written notice to the general contractor again. And it has to be furnished within 30 days of your first date of work. If you don't provide that timely written notice, you've forfeited your claim. Okay. Now, what's the deadline to file a lawsuit on a claim? It's kind of a confusing limitations period. You'll notice here you can't file a lawsuit too soon and you can't file it too late. So you have to wait until 30 days has expired after final acceptance. If you file before that, court can dismiss it with the right to refile later. Okay, so you might get kicked out temporarily for filing too soon. But the main one you want to make note of is it's no later than 60 days after final acceptance and completion of the project. So that final acceptance that triggers the 30-day deadline to file claims, it also triggers a 60-day deadline to file a lawsuit. Okay, so it's a really short limitations period, so you got to remember that. Attorney fees. It is in favor of those claimants who file these claims that we talked about. They can recover attorney fees. There's an open question in Iowa whether that also applies to a general contractor who has a retainage dispute with an owner. Supreme Court of Iowa has not addressed that issue, so that's an open question, but it does clearly apply to those like a subcontractor who files a claim. They can recover attorney fees. Okay, for federal projects, the Federal Miller Act applies. It's similar to the Iowa Little Miller Act, except there's no retainage. The claim's only against the payment bond. Okay, there's no retainage, so it's just a bond claim. Again, those who do not have a direct contract with the general contractor, for example, so sub to a sub, they have to give written notice to the general, just like under the Little Miller Act. This one's much more generous and than the Iowa Little Miller Act for claimants, because the notice has to be given within 90 days of the claimant's last date of work. Compare that to the Iowa Little Miller Act, the notice is within 30 days of the first date of work. Okay, so the Federal Miller Act lets you wait until you're done and you have 90 days to file your notice or give your timely notice to the general. If you don't do that, your claim is barred. Now, what are the contents of this notice requirement? I'm not going to get into the details, just understand that it's kind of confusing based on these amendments to the Miller Act back in 2002. What I can tell you is the requirement should be you have to describe the material and labor furnished on the project, who you furnished it to, or the labor or materials, and then the balance owed. Make sure you try to provide as much detail as you can in your notice to the general. Now, how long do you have to file a lawsuit? You have no later than 1 year after your last day at work. So again, compared to the Iowa Little Miller Act, which is based on the owner's acceptance of the project, which is 60 days from that, the limitations here is a year later, a year from the claimant's last day of work. So this is based on the claimant specific. The Iowa Little Miller Act is project-based limitations period. So they are different, keep that in mind. Okay, we're going to turn to contract claims provisions, and I'm going to use the AIA 8201 provision because that's a standard contract that's used in a lot of commercial projects. So it defines in this section what a claim is, and essentially a claim is going to be any demand for payment for one, change in or additional time. So it can be a claim for money, it can be a claim for time, or a demand for other relief. So essentially anything you're demanding as a contractor is going to be a claim. And then what that does is it typically triggers a notice requirement. And at the bottom of this, you'll see the written claim notice that the claimant has to give to I always give it to you have to give it to the other party. So for example, if you're the general making a claim against the owner, you have to give the notice to the owner plus the initial decision maker. Typically that's the architect, but you want to take a look at the contract and see who's the initial decision maker. Typically architect. You have a written notice requirement of your claim within 21 days after the event giving rise to the claim. So it's fairly short. These get modified a lot by owners, especially on public projects. So make sure you review them. Sometimes they substantially reduce the deadline from 21 down to 7, for example. And sometimes the owners in public projects modify this to remove themselves from the requirement to give a claim notice. So it only is the general contractor who has to give the notice. So keep that in mind. But point is, read the contract, make sure you comply with this provision to preserve your claim rights. Now, the notice, I just want to point this out. The AIA has these 2 provisions about notices. The top one is just generic notices, says you can deliver them by mail, courier, or email if parties have agreed. The bottom one is for notice of claims. You'll notice it says it's only served if you send it by certified or registered mail or by courier. I don't like that provision because it defies reality. People communicate by email and more informal now, and that's the way things get sent. I'm not sure if someone sends an email notice, claim notice by email and everybody receives it, if they're going to get dinged on that. I know in the federal Miller Act context that I mentioned, there is a provision in the statute that's very specific on how you have to serve your notice. If that notice that you have to give if you don't have a contract with the general, it's very specific. The courts have said as long as the general gets it, it's fine. So if that's the rule for a statutory requirement, if you have a contractual requirement here and it's the owner and the architect get it by email, I just don't see a court dinging you on that. But you never know. Keep this in mind. Certified mail or courier is obviously the best way to do it if you have that provision. Some courts have dismissed payment claims if you don't provide that 21-day claim notice. So keep that in mind. Not all provisions result in a waiver, but some do. So you want to make sure you read it and comply if you can. And the lesson is read your contract and follow the procedures and deadlines and other requirements. That's the best way to preserve your claim rights. If you miss one or don't comply with one, it doesn't mean you're necessarily out of luck. Probably consult with your attorney then. Okay, finally, we're going to move on to lien waivers, the last section. Conditional waivers. So progress payments are often, and even some final payment are often conditional, namely they're conditioned on receiving the payment described. So if you don't receive the payment, the waiver is ineffective. Pretty standard. Then you have unconditional waivers. Those are typically the unconditional final lien waiver, which means it's unconditional. It's not conditioned on you receiving payment. So even if you don't receive it, and if you've signed an unconditional waiver, your waiver can still be effective, meaning you can't file a mechanics lien potentially. Maybe you can still go after the person who didn't pay you, but you can potentially lose your lien rights if you sign that. So you want to make sure you read the waivers you're signing. Case law. What's the case law in Iowa? Essentially what this means is the courts are going to construe any ambiguity in favor of the claimant. So the subcontractor filing the lien waiver, they're going to construe any ambiguity in favor of that subcontractor. What's that mean? If there's any ambiguity, they will construe it as a conditional waiver, okay, not an unconditional one. However, if the language is clear that it's unconditional, then that'll be enforceable. But the courts will construe any doubt in favor of the subcontractor. So general contractor, if you're wanting an unconditional lien waiver from your subs, make sure you're clear on that. This is just a case to note that addressed that issue. And again, here the court essentially said, no, this was a conditional lien waiver and they did not intend to waive their mechanics liens for amounts they hadn't received yet. So that's an example of the court construing in favor of the subcontractor because there was an ambiguity. Okay, a preceding waiver. What that means is the waiver is only limited to what work you've already furnished, not to future work, okay? A prospective waiver applies to future work, okay? So you can file a lien waiver that waives your right to file a lien for future work. What's the rule in Iowa? Again, if it's ambiguous, it's going to be construed only as a preceding waiver. It only applies to work you've already furnished and not to future work. But if it's clear, it will be construed to apply to future work. Same thing. Here, the waivers, so had Baker intended to waive subsequent lien rights, the waivers could have been modified to do that. So the point here is the court said, this is ambiguous. I'm construing it as a preceding waiver, not a prospective, because if you want a prospective, you could have made that clear. One last slide here. Iowa, as I mentioned, does not permit liens to be filed against public property. So any lien is void. And Iowa Little Miller Act and Federal Miller Act apply retainage or bond system instead of liens. So the question is, if you file or sign a lien waiver on a public job, are you waiving your right to file a Little Miller Act claim? I don't think it is, because I don't think it is a waiver of those claims, because it's clear that claim is not a lien. And so the point is, if you're a contractor and you're wanting your subs to file a lien waiver, what I suggest is you get a blanket lien claim waiver that has language that says they're waiving lien rights, Little Miller Act claim rights, and Federal Miller Act claim rights. You can use them on all your projects. That way, if you're in a public job, they're waiving these Miller Act claims. If you just have lien waiver language, you could be essentially not getting a waiver of any claim rights at all. So keep that in mind. Okay, that's it for the substance of the presentation. If there's any questions, I don't know if there's any questions that have been submitted. Jesse,
there are a couple of questions. Well, thank you so much, Steve. I really appreciate it. You are not wrong. People need to be really cautious and read their contracts, read their waivers that they're signing, so that way you're not forfeiting any potential things that you don't want to forfeit. Okay, so for the questions that have come through, the first one, it says, can I amend my lien to correct amounts or entity names, etc., if I'm still within the deadline to file? And then are there any exceptions to amend it after the lien deadline?
So good question. So amending of liens. So in Iowa, if you're amending your lien to reduce your lien amount, you can do it on the Secretary of State's website. And that's an easy process. So the answer is yes, you can do that at any time. But if you filed a lien for, let's just say $10,000, for example, and then you're like, oh, I want to add another $10,000 onto it, you cannot add it onto that lien. You cannot amend it to increase your lien amount. What you have to do is file a new lien for that second $10,000. And the reason for that is, as I mentioned, when you file your liens, there's certain priority dates and all this kind of these rules that apply. So the courts do not allow you to modify your lien upward and maintain that priority and filing date. Okay. So the answer to your question is, if you want to file a lien or increase your lien amount by 10 grand, you're going to have to leave your original 10 and you have to see whether you can file a lien for the second 10. If you're within 90 days of your last day of work relating to that extra 10,000, then you file it and you're within 90 and you get the relation back and all that. If you're beyond 90, then you got to do all the things I mentioned, serve the lien, and then you lose your relation back, and then how much is owed by the owner to the general. So those kind of things. So general answer is you can amend downward, you cannot amend upward, and if you want to add amounts to your lien, you have to file a new lien.
Okay, perfect. Thank you. Another question that has come through, it says, on a bonded private commercial job, can I do the lien and the Little Miller Act? Or a bond claim?
On a bonded private job, the Miller Act does not apply. Okay, so the Little Miller Act only applies to public jobs in Iowa. The Federal Miller Act only applies to public federal jobs. If you're on a private job, there is no claim against the retainage or a backup claim against the bond like there is in the Miller Act. So if there is a private payment bond, there are sometimes a general or an owner will require a general to provide a payment bond on a private job. If that's the case, you have to get a copy of that bond if you're a sub and want to make a claim against it, and see what the requirements are and comply with it. You might have to give notices. You might have to file suit within a certain period of time, but you gotta read your bond and see what you're required to do. So that's the general rule on that. If your question, if you have a follow-up question on that, let me know. But that's the rule for private bonded jobs.
Yeah, I think they're just specifically asking if they could do the lien and a bond claim, like for that same project, or if one trumps the other one is kind of how I take it.
If there is a payment bond claim, you can do both. You can file a mechanics lien and you can pursue the payment bond claim. Iowa doesn't have a provision that allows an owner or a general to post a bond that essentially replaces the ability to file a lien. I think some states do, that certain owners can say, hey, general, post this bond, and that way any subs who want to file a lien, they file against the bond and there's no liens on my property. They don't have that in Iowa. Now, if you file a mechanics lien, owner or general can furnish a bond to bond off that lien, but it's got to be specific to each lien claim. So if you are a claimant in Iowa on a private job, a sub, for example, I would suggest you, and there's a bond on there, I would suggest filing a mechanics lien and looking at the bond and going after both of them.
All right, perfect. Thank you so much for that clarification. I do think that that's all the questions that have come through. If anyone does think of another question that wasn't addressed, please feel free to reach out and we'll be sure to answer those questions for you. All right, so here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. Please remember each state has its own unique lien laws, rules, deadlines, bond claim rules, all that kind of stuff of what documents are required and what the deadlines are associated with it. So please, if you're working in a neighboring state or something that you're not familiar with, go onto our site, you can check it out, put in what type of project it is, and it will kind of break it down of what types of documents you're actually needing to send. And then the next slide, please. All right, if you don't mind, give us a quick moment of your time. We really do appreciate any feedback that you can provide to us. It helps us always better ourselves and the content that we're putting out for you guys. And then the last slide, if you don't mind. All right, that is all we have for you guys today. Thank you so much to everyone who attended. We hope to see you guys at our next webinar. Again, thank you so much, Steve. You really are wonderful. I really do appreciate you breaking it down for us. I hope everyone has a beautiful and wonderful sunny day and stay safe in your snowstorm.
Yes, thanks, Jesse. Thanks, everybody.
Thank you, everyone. All right, bye-bye.
Bye.